Welcome. I just got the thumbs up, so we'll go ahead and get started. I am Kristen Osenga, and I am delighted to moderate this panel with my fine panelists. I'm not going to say much about them because you have information about them, and they will certainly, I'm sure, let you know about them as we go down the line. So the topic of this panel flows nicely, I think, from the previous panel that was in the other room. We're going to be talking about FRAND hotspots. Although their interpretations of FRAND hotspots are slightly different as we go down the line. So this should be a really interesting discussion. And without further ado, I'm going to turn it over to Kurt to start.
Thank you, Kristen, and thank you for the invitation to speak here today, and thank you to George Mason for putting this on. Many of you were probably at the last panel, and so you've heard a lot about what's happening in Europe and elsewhere with respect to these proposals to regulate standards-related patents. There's several reasons for concerns. I'm not going to reiterate the ones that you heard before, just touch on them briefly, but the impact on foreign patents is a big one. And just frankly, upsetting a balance that's worked well for decades and many generations of wireless technology. What I'm going to focus on in particular, some of the arguments that are being advanced, because many of them are unsupported by the evidence or frankly, in my humble opinion, nonsensical. And I want you to keep your ears open for something today. What you're going to hear is there's a lot of non-legal and vague terms that get thrown around to try to encapsulate what people think are the concern. But I'm going to, again, just reiterate that these aren't really well defined terms and aren't necessarily agreed on, and two of them are holdup and transparency, and we'll touch on a couple of those later on. We're open to, I think, as patent owners, doing things that could lead to more efficient licensing, but we certainly don't want to do things that lead to more holdout. I work for a small company, it's called Harfang IP. We acquire smaller compared to Qualcomm, for example. Not all patent owners are like Qualcomm, but we get often lumped together. We're a relatively smaller company that partners with operating companies. We buy their portfolios outright to monetize, or we partner with them, sharing in a back-end arrangement. And given our location and the makeup of our portfolio, we're particularly concerned with the U.S. market. And as a result of that, we often use a few different filters when we're looking at these proposals to see how that lines up with U.S. law, because unlike Germany and injunction and the ITC and many other places that are concerned with injunctive relief, it's practically speaking not a possibility in district court. It's all about past damages for past infringement, or all about damages for past infringement. So the filters we often apply, I say we, it's my partner, the owner of a company, we write a lot of articles together. We often look at, well, what's the language of the contract? A lot of these licensing assurances are all treated the same, but they're quite different. The language differs from if you're talking about ETSI, or if you're talking about the IEEE, or the Wi-Fi Alliance, for example. What's the contract say, and how would contract law apply? Also, what's the remedy that's being discussed? Are we talking about an injunction, or are we talking about damages for infringement? And when we're talking about an injunction, what's the assumptions being made about market power? Again, not all patent owners are the same. And then finally, we often look at claims to improving efficiency. Again, are they really addressing a particular problem that we can identify, or is this again just going to lead to more delay and excuse holdout? And the four main observations that I want to touch on today. Number one is that the contractual obligations are often misinterpreted, and contract law isn't even often considered. In particular, one thing we've written about, you talk about obligations to license on FRAND, doesn't say anything about releases for the past. A license is something that is forward-looking, and whereas a release is with respect to the past. You also see the burden with respect to the condition of essentiality being shifted onto patent owners, and the contract not being able to be discharged despite a lack of cooperation from the would-be licensee. And collectively, this upsets the balance and allows implementers to profit from infringing, yet cap their exposure at FRAND, and then use that money to fight against the need for licenses, or try to invalidate the patents, or throw in a breach of contract claim or an antitrust claim, or whatever you want. And we discussed we call this having your FRAND cake and eating it too. A second main observation is that injunctions really dominate the narrative here, and damages aren't often distinguished, but they're quite different. The dynamics are quite different. And that comes back to that previous point about how the contract gets interpreted. There's no holdup when it comes to seeking damages for past infringement. Access, you'll often hear access as another code word for holdup. An injunction will prevent access to the standards, but there is no holdup problem. It's like the movie There Will Be Blood. They've already drank your milkshake. Like, access to the standard is the problem. That's where you guys laugh, by the way. Access to the standards is the problem. It's not a lack of access to the standards. You see the European regulations, for example, just referring to the enforcement of patents generally without making that distinction. A third point, when you get to injunctions, again, I call it this injunction fever that's sort of taken over this space. Ownership is often equated with market power. There's a quote I have I can read if you want to hear the whole quote, but basically the European regulators say in the proposed regulations that with this power of having an essential patent, implementers are forced to either pay the amount that's being demanded or they have to stop using the technology. Well, the standard essential patent is not a magic wand. You still have to go to court and win on a variety of issues before you ever get to an injunction. If you look at Lenovo, it took them over a decade. InterDigital, when it came to Lenovo, it took over a decade. The European regulators seem to be missing the third most popular option, which is you just use the technology without a license and wait till you're chased. And again, use all that money then to fight against the need for licenses. And again, I'll come back to this point that even when it comes to injunctions, it's not as if the patent has inherent power. In the case of, if it's Qualcomm and you're a small implementer and they've got thousands of patents in deep pockets, that's one thing. But if you're just talking about a single patent, the abuses are far less. And so I would submit to you, one other point on this. You also see the idea of one patent being used, an injunction on one patent to leverage a broader deal. That's a problem that gets bigger with the size of a company. But if you're just talking about an individual patent, where's the abuse? You have your opportunity in front of the judge or whomever to make all the arguments you want to make. And so it just seems there's a lack of nuance around a lot of these issues. All patent owners are sort of treated the same. Patents are seen as having this inherent power. And now we're seeing, despite the fact that it's hard to see what the problem is in terms of antitrust and competition law issues, you're now seeing a lot of concern for SMEs and the narratives that these small and medium-sized enterprises aren't going to want to innovate if they can't get a license. And the idea that somehow, this threat of the injunction is going to cause them not to want to implement in this space. But, why won't they just do what the car companies and the phone companies did and just not pay and wait till they get chased down the road? A little more practically speaking, it seems preemptive because you're not allowing for industry solutions like Avanci or Sysful or others to try to come up with a solution before it's already, trying to come up with a solution to a problem that might not exist. How am I doing my time?
You're just about out.
I'm just about out. All right, I'll just say on transparency, the narrative is that implementers, they really don't want to profit from this system where you can actually make a lot of money by infringing and not paying. They just really need more information. If they just had more information, then they, would want to pay for these licenses. But a lot of information is public. The patents are public. The standards are public. The Etsy database is public. A lot of announced rates are public, so on and so forth. I'd submit to you it's more about shifting the burden of proof, shifting the cost of the analysis, and shifting the risk. And with that, I'll turn it over to Fabian.
Thank you, Kurt. As you can tell from Kurt and Kristen's little conversation there, Kristen put the fear of God in us about going over time, and so I have my phone in front of me with a timer so to make sure that I don't fall afoul. So hot topics to me are, what is really affecting how I help my company operate in the marketplace, and I mean the licensing marketplace, the licensing environment. And that has to do with how the law is changing, how it's evolving, what courts are doing, what the cases are saying. It has to do with regulation as well, but the EU regulation is far off if it ever is going to happen, and so that's not a consideration right now. Right now, the things that I'm thinking about the most are how how we litigate FRAND disputes is changing, how courts are actually deciding FRAND terms, because we increasingly have that occurring, and the question of jurisdictional differences. Doesn't matter where the cases are. So let me talk a little bit briefly about each of those. So to me, the primary way how we litigate is changing is that the focus is coming off of conduct and coming more onto what the actual offers are, what the actual economics are. What do I mean by that? So for litigators always look, I was a litigator, and I'll say litigators always look for the win button, the issue that if you win the whole case, that's it. It's maximum pressure on the other side if it looks like you're going to win it, or et cetera, right? And FRAND has been replete with people on both sides looking for their win buttons. And it's been, oh, well, if people are holding up, if they're asking for too high royalties, then they shouldn't be allowed to enforce their patents at all. Or if people are holding out and they can show their unwilling licensee, they should lose their entitlement to a FRAND license forever. As examples. There are other examples as well. I can give you a whole litany of all the win buttons. But a lot of them have to do with conduct, the conduct of the negotiations. And so litigators in these recent cases have spent a lot of time criticizing the other side's conduct of the litigation, asking for too much, holding out, being unreasonable, et cetera, et cetera. And all of that courts are telling us is a waste of time. It's a waste of time, it's a waste of money, doesn't matter. The judge in the Apple Optus case basically said, hold up and hold out. That's just people trying to exercise their rights. Maybe there's some limit at which it's a problem or unlawful. Doubt it, but maybe there is. But certainly that's not the case here. And so all of this has been a waste of time. And instead, what they're focusing on is what has the offer been? Has it been FRAND? If not, what is FRAND? And then is the other side willing to take a FRAND offer or not? That's it. And I'd say that simplifies litigation quite a bit, and that probably puts the focus where it needs to be. So how are courts deciding FRAND terms? Well, the UK courts are the ones that are doing it right now. We will soon, at the end of this month or beginning of next month, see what the Chinese courts actually do with Nokia Oppo, because there's been a lot of talk about China doing it, but they haven't actually done it yet. But I'll just say I fully expect that decision to come out within a month, and we'll see what they do. But what the UK courts are doing are deciding on a case-by-case basis. So there's not these grand principles. They're not deciding if they make some kind of finding as to, well, it looks like the whole stack is 8%. That doesn't bind any future determination or anything like that. They're doing them on a case-by-case basis, and they're using what I'll call the least bad evidence. You have to understand that the approach the UK courts are taking is they have to get to a decision. And so if there's a failure of proof, if the evidence is bad, so bad that in a US court, whoever has the burden of proof would just lose, they still have to do something. And that's what they're doing is like looking at the least bad evidence. And then whoever's the least unreasonable kind of wins. And so really skilled lawyers matter a lot in these cases, right? So, again, back to Apple Optus, Tim's colleague, Anthony Trenton, did a masterful job in that case, and ended up getting a really good result for his client because Apple, even though a lot of Apple's methodology was criticized and thrown out and all of that, ultimately they had the least bad evidence, and so they got a result much closer to what they wanted. Last bit, I'll talk about jurisdictional differences. So a big open question in standardization generally is, are FRAND determinations going to be consistent across jurisdictions? There's lesser questions about then if they're not, then who decides and what happens. But global standardization is going to depend on whether those decisions are consistent or not. If they are, then the system will go forward and the system will work. If they are inconsistent, that will, over time, break the system. It'll take time because licensing occurs over time, but it will break the system. With that, I will give up my time.
Very well done. Tim, go ahead.
I used the same. Is it on? I used the same timer like it. Make sure. I'm keeping the time to it. Tim Pohlmann with IPlytics or IPlytics LexisNexis now. For those who do not know me or the database, IPlytics is a database that basically provides access to any publicly available data point on declared patents and pooled patents out there. And those data points are often used in FRAND negotiations as one reference point, typically a starting point with all the limitations of what data brings, that it's, of course, when we look at patent declarations, there's no validity checks, there's no essentiality checks. And we can assume that validity and essentiality is not evenly distributed among patent portfolios. So, of course, if you look at declaration data only, this may be, beneficial for some companies and not so beneficial for the others. I think what is important always to us is that at least that foundation and that starting point is accurate, because even there we have different reports out there that do not even describe how they came up, what is 5G to them. Did they deduplicate? Are they counting families? How do they do that? All these different ways of tricking and refining data differently. We want to be as transparent as possible about the methods of how data is refined, and that's also one part of the transparency that is really important to us. Other things what we observe, and we really work with both sides of the table, the big SEP holders, same as the big implementers, is of course that after that first starting point, there are other reference points, comparable licenses, but also of course sometimes things like valuation metrics or a sample of claim charting that should identify some essentiality rate for these portfolios that you can apply to the starting point data. And I think as an economist, and this is maybe outside of even our business model, but I've been also involved in many studies, there's one major concern I keep having with that is that people only care about what is most accurate without thinking about a bias, a systematic bias of systems. And we at IPlytics, we have a biased system. We do compare claims with sections of standards. Why do we do that? Because it helps when someone wants to do claim charting that the most likely and relevant claim relates to the most likely relevant section, and that helps people. But if you would use that indicator as having a essentiality score, we found out that it actually overrates a lot of the patents that are using certain language and claims and using certain language and sections. And it typically also overrates patents that are not essential. And that is a systematic bias towards overrating less essential portfolios compared to the essential portfolios. And we find actually similar biases if you don't do rigorous claim charting, which is just a 20-minute lookup. So those are things that you always have to consider, what is the bias when evaluating two portfolios? Because to me, FRAND is always the appreciation of the value of each other's portfolio. I mean, this is really what it's about, right? Lots of what we learned today is also cross-licensing. So do you have good data and reference points to find evidence that you have a valuable portfolio compared to the other portfolio, or if it's a pure implementer, compared to other deals that the implementer closed with other SEP holders that may have smaller or bigger portfolios. And I think it's often a combination of publicly available data and private data and other metrics as success in the market, of course, that are combined to find out what FRAND is, or to find out within Avanci how revenues are distributed, which is also a combination of different data points. And that really is FRAND determination for me. I think the hot points right now are that, of course, we are going beyond the smartphone world. There's automotive, but even beyond that, there's also IoT. Smart metering and device tracking devices are the next licensing on the horizon. But a 4G, 5G, NB-IoT technology doesn't need all the features of 4G and 5G. No video, no audio needed. Even latency is not so important. So what are the actual patents relevant to these use cases? So, even if we figured out 4G, 5G, we now have to break down further and see which are the relevant patents here. There's a pool. Syrett right now is setting up. They, I guess will come up with some rates and some patents soon. And with all that, again, new data points, we at IPlytics try to help to find and understand, shed some light into what is going on there. But I think these are challenges, again, because we are entering new markets. I learned that in the smart metering, we have a similar issue that the OEMs get a chip that from a supplier that they don't feel responsible for. They're typically indemnified. And the same we learned from the auto industry is starting all over again, where there's there's licensing on the OEM level, and the OEMs have little experience in licensing, and there's an education in the market going on again. And those are hot topics right now because, of course, I think it's for everyone beneficial when deals are closed within a certain time, and we're not waiting for 10 years to get royalties in. 9 months is very ambitious for that regulation proposal. Maybe that is too short, but finding agreement between both parties is, I think, mainly what FRAND should be about. Thank you.
So my name's Tim Syrett. I'm a IP and antitrust litigator at WilmerHale in Boston. As Fabian alluded to, we tend to represent licensees in these disputes. So when I hear the question, where are the hotspots, as a litigator, I think very much about jurisdictions. And when these disputes happen, they're typically global in nature, and they will spill over into multiple countries, multiple courts. And I think in terms of where is the highest risk of an injunction, because that poses the greatest risk to my client typically. And Tim was talking about trying to figure out what's the value of the patents. I think when a credible threat of an injunction enters the picture, the discussion moves away from that, and it becomes really about what is the cost of avoiding being shut down in a given jurisdiction, and if that jurisdiction is big enough, that's a huge cost. That's how I think of hotspots. And at the top of my list, in terms of the hottest of hotspots, would be Germany, where the courts have been, I think, very stringent in terms of their application of the Huawei ZTE framework. It sets forth a kind of a 4-step process, a back and forth between the parties, and it recognizes that there should be, in appropriate circumstances where a licensee has demonstrated willingness, there should be available a competition defense. But German courts, I'm not aware of a German court finding. Sorry, I'm getting. Sure, I'm not aware of a German court finding a licensee willing, having applied that test, and in fact, some German courts have shifted the test around. So in the third stage, the licensor is supposed to make a FRAND offer to the licensee. If the licensee disagrees with that, doesn't accept it, it's supposed to come back with a FRAND counteroffer. But some German courts have started looking at the counteroffer first before looking even at the initial offer from the licensor, which I think reverses the burden. It puts the onus on a licensee who's not going to have as much information about the patents at issue as the licensor. And I think it stacks the deck against you as a defendant. And so the last panel obviously the last panel on FRAND dealt a lot with the EC SEP regulation. I won't go into that in detail, but I do think there is some value. It has flaws to be sure, but there is some value in interposing a neutral party between people who are negotiating to give an opinion on what is FRAND. And there's talk about transparency in terms of patents and so forth. But at the end of the day, I think that it's the dollars that drive these decisions. And there are announced rates. There is information that comes out in cases like the InterDigital Lenovo decision, Apple Optus. So we always get more information. But there is a lack of information about what people are actually charging in a lot of circumstances. You can have an announced rate, but it can differ substantially from what is charged in the real world. And so I think clients want to know, what are my competitors paying? And I don't want to pay more than that. I want to pay around that. But they don't have access to that because they're, people for good reason want to keep their licenses confidential. But if you can put in a neutral third party who could mediate, I think it's not going to be a silver bullet, but I think it would bring people closer together. If your position is kind of rejected out of hand and the neutral third party is much closer to your opponent, if you're smart, you're going to rethink your position. In the U.S., I agree with Curtis that the prospect of an injunction in district court on a FRAND committed patent is low, very low, absent some exceptional circumstances. But we do have the International Trade Commission, which at the full commission has not dealt with the issue since 2013, but in 2013 it did issue an exclusion order that was overturned. And since then, the administrative law judges have, I think, been skeptical of FRAND, to put it mildly in some cases, as factoring into the public interest analysis that they're supposed to do. They're not governed by eBay and the same equitable considerations as district court, but they do have a public interest framework that they apply and have kind of rejected that FRAND fits into there. And just briefly, a couple emerging jurisdictions. I mean, obviously, Fabian touched on China. It's always at the center, and I think it will continue to be at the center of these issues given its size. But we've also seen other countries emerge as potential destinations for FRAND litigation. India, in March, there was a decision likening a SEP to a silver bullet and saying that it would be appropriate that basically a patent holder should be able to exercise the right to use that silver bullet and stop someone from selling on one patent. And then South America, there's been a fair bit of FRAND litigation in Brazil over the years, but Colombia recently in the Apple Ericsson litigation became a hotspot. And both Brazil and Colombia, like Germany, are bifurcated systems. So you figure out infringement first and invalidity separately and often much, much later. So if you're seeking an injunction, there's a benefit to just having to get over the infringement hurdle and not deal with invalidity. There are some other ways in which those systems work, that the availability of preliminary injunctions is more readily available, certainly than in the U.S., makes them attractive forums.
Okay, great. Thank you all for that. I did promise them when we set up in this order that I would let them respond just very briefly to each other before we move into questions, because I'm sure Kurt probably has things to say in reaction to things that were said down the line. And so I'm going to give you guys each just a couple minutes to refer to any comments of the other folks that you'd like to.
Thank you, Kristen. I think Tim makes a valid point from Tim Syrett. So we have two Tims on the panel. Tim Syrett makes from an implementer standpoint, the injunction is the biggest issue, but I would ask, should it be? Perhaps it should be enhanced damages for willful infringement. That should be a concern. I think David Kapos wrote a paper on that, making the case for enhanced damages, and I tend to agree with him. Also, I think a concern should be a loss of entitlement to FRAND. It's hard to know where the line should be, but as a matter of contract law, you can't force contracts unless your name's Don Corleone. You can't force a contract on anybody. It has to be an agreement. If one side to that agreement, if it requires cooperation, in order to get a FRAND license, then there should be the possibility that obligation can be discharged if the other party is not cooperating. And then I just want to really quickly touch on the transparency thing. The thing with the biggest problem I have with the transparency when we're talking about the European regulations, proposed European regulations, is they don't ask for that information. They're not saying to everybody, turn over all your licenses. And it's not unlike other industries. If I owned a restaurant, I would know how much I paid each of my suppliers for vegetables or booze or something else. But I don't know what the other restaurants pay. And if I'm a supplier, I know how much everybody pays for tomatoes, but I don't know what they're paying for other things. And that's, it's not required under the Etsy contract, for example, or any of the license assurance contracts I'm aware of. And frankly, implementers play a big part in that. They don't want their contracts. It's one thing to want transparency of everybody else's contracts, but when it comes to their own, oftentimes implementers want confidentiality. You want to add, Fabian?
So on Germany and injunctions, there are cases that where licensees have been found willing, and the defense has been available, but you don't hear about those, obviously. But in general, I'm not aware of a case where an injunction was issued and that ended up resulting in the infringer actually signing up to a FRAND license. So, the cases that get the biggest noise lately were the German auto cases, the cases against German automakers or Ford arm in Germany, and they ended up getting the exact same license terms as the people who didn't litigate, the people who signed up first and didn't litigate. So it's hard to think of that as a problem without evidence. But in any event, I wrote a post on LinkedIn, if you guys want to see it, that talked about the solution to this is to create a mechanism so that FRAND is considered before an injunction is enforced. And if the patent holder has made a FRAND offer, then sure, then it can be enjoined because they aren't accepting a FRAND offer. And the patent holder hasn't made a FRAND offer, well, then they don't get an injunction. I think patent holders would be fine with that. The EU proposal doesn't do that and doesn't address that. EU proposal also doesn't address transparency of what people are paying, as Curtis said. Should it? Maybe it should. That certainly would make more sense to me as a matter of transparency than a lot of it. Whether it actually would make a difference in some negotiations or all negotiations, not all of them. I mean, I've had a licensee tell me to my face after asking for comparable information and me finally getting permission to give it to them after hearing it, telling me literally, I don't care what X is paying. Exact quote. It was amazing. So it's certainly not going to make a difference in all negotiations. But would it make a difference in some? Sure.
Maybe the only thing that I would want to comment on is the transparency part also. As a database, of course, we try to increase transparency. And I think, at least to some extent of that EU regulation, I do think that some of the points they make on increasing transparency, especially for standards where there's not such a extensive database as we have with ETSI, some transparency would really help both sides of the table. I keep talking to SEP licensors, and many say if my competitors would declare all their Wi-Fi and video codec patents, I would do the same, but I don't want to be in the public when they don't do it. So it's kind of like a chicken and egg thing, and I don't think there's much of a burden also to the SEP holders to do it. Also, I think that, to a certain extent, to provide some more information on which are the most likely claims that you feel could be essential, providing that information, I think also wouldn't hurt too much. So it doesn't maybe have to be claim charting each and every patent. Also, sampling is difficult. Keith Mellison wrote an actually great report on, how much percentage of sampling is needed, and even that is super costly. And I can tell you the database changes every day. So a truly representative random sample is a data point today. Next year, it's outdated. So those kind of considerations you have to think about when you start creating these databases. How can you maintain it? Can you do it for all standards generation out there? Or, are we concentrating on cellular? But I think some transparency comes at a not so high cost and not such a big burden. And I think it could help both sides, because if you're an implementer, you at least want to know who owns a considerable portfolio in Wi-Fi 6, right? That's a fair ask. And they look at standards contributions, and we can give them some estimations as well. but it would be great to have some more data points to be more accurate there. So that's my comment on transparency for data.
One quick response. Our last submission to IEEE disclosed our actual patents. So people that are telling you that, well, if somebody else did it, we would too, they're lying to you.
Okay, back down to Tim at the end, please.
So just on the, just to respond to Curtis on the transparency point, I mean, I take your point on the restaurants, but I think it's different when, if I'm coming to you as a licensor and I want assurance that other people in my position have paid what you are asking me to pay, I think that's a different situation. And having litigated cases, the licensor will be saying during the negotiations, this is our standard rate, everybody pays this, you should pay it too. And then in discovery, you see the license, and I'm obviously not going to go into specifics, but you see the licenses, and yeah, some people have paid it, but not most people, and not people that you would kind of consider similarly situated. And so I think that's information that my client, who's not under the protective order, is not going to have. And so I think, I agree with Fabian. If there were some way, and I think maybe it was Curtis or Fabian, I'm not sure. I think it's both sides. I mean, licensees don't want their licenses out, and a lot of licensors don't either. But if there were some way to increase the transparency, I think of what people are actually paying, you would see a lot less in terms of disputes. It might put me out of a job, but it would certainly cut down on a lot of the problems that we see.
Okay.
A
Can I
2-second
stop you? No,
response to that?
go ahead. No, go ahead, Greg.
Hard over rule. I'll just say that the issue with that, Tim, is that I'm okay with transparency if there's a result that we're going to get to. And that's the difference when you talk about civil procedure. Yeah, there's discovery, but we're going to get to a result. And the same thing with arbitration. I noticed you mentioned mediation earlier, but not binding arbitration. Again, as a patent owner, I'd be more willing to turn things over, and I'd have an easier time getting other licensees to agree to doing that if they knew it was going to be subject to a protective order and they knew it was going to, get to some sort of result. But the problem we're seeing is that a lot of this information is wanted up front. It's not reciprocal, and there's no result. Nothing's binding. So it just will lead to, it sounds like the best intentions, but in reality, it just looks like it will lead to more delay and more cost for patent owners.
Okay, so you guys are very excited about transparency, so I'm going to ask a question that was alluded to in the previous panel that I don't think they answered entirely, and maybe you guys have thoughts, and I'll toss it to whomever wishes to answer first. But one concern that's been raised about transparency and having more information about what these licenses are is the potential for collusion, and having more data makes it easier to collude. So do you guys have any thoughts on whether or not that is a real problem? Is that something we shouldn't even be worried about?
Pass on that
I
one.
mean, I guess theoretically it could make it more likely, but I think if you're going to collude, you can find ways to do that anyway. So I'm not. I guess I don't see a direct link between creating more transparency and creating a significant risk of collusion. I mean, I think Fabian's going to do his best to act on behalf of Qualcomm, and maybe he can be more informed about what that is if he knows more about what other people are doing. But does that mean he's going to pick up the phone and call his colleague somewhere else and fix prices? I think if he wanted to do that, he would do that anyway. And same with licensees. So I guess I just don't see a direct causal link. Maybe it's one step on the path there, but it doesn't, to me, cause a big alarm.
Yeah, so I'm going to agree with that. I don't think that even if you had a situation where all license agreements were public, I don't think that materially affects the incentives or opportunity for collusion. And and the reason I think so is grounded in the real world. I mean, in the real world, everyone has had the experience that confidentiality obligations are just less respected in certain parts of the world, or that people move around more, or just everyone ends up knowing what's going on. That's just a reality. And I have not seen a material difference in those jurisdictions than in jurisdictions where confidentiality is more respected.
This is another one of these big company, small company issues that gets, or maybe I'll call them big portfolio versus small portfolio, where they kind of get lumped together. You know, we hear this discussion about rates all the time, and you see all these cases, and they're talking about running royalties. That's not how it happens for owners of small portfolios. We do lump sum deals. That's what the big companies want, and nobody knows what the rate is going to be until many years down the road, because we don't know how many sales, volumes are going to have over the years and all the rest. So a lot of these, I guess we could call them idealistic solutions, just don't apply to smaller patent owners. And again, I just want to keep reiterating this point that we're not all the same. They're often lumped together, but these solutions just aren't going to work for us. I have no idea. I don't have a crystal ball to know what somebody's sales are going to be 5-10 years into the future to then deal with the next person and try to make theirs the same.
Maybe one final comment. It's also not all black and white. I mean, most licensors are also implementers, and they have to come together with the other licensors, find agreements. So it's not like the licensors in the corner collude and the implementers in the other corner. Apple has a big portfolio. So, I mean, I think it's not all black and white, and therefore I could also see that, as Fabian and also Tim said, is probably not going to happen because it's a much more complex world we live in, right?
Okay. So another topic that came out of many of your opening remarks is jurisdiction. And what I'm wondering is one of the things we think about in this weird academic space, because I don't actually have clients and don't have to think about anything that's real, is that when we have multiple... I know, you want to come on over? It's fun. One of the things we think about when we have different jurisdictions doing different things is how appealing that is, because it's natural experiments, or it's a laboratory sort of. We can see what works, what doesn't work. But I get the sense from the previous panel, and in part from some of the things you guys said, that the differences in jurisdiction isn't actually a good thing. Maybe it's not a good thing. So thoughts on that? Is it good for us to have jurisdictions that are doing things differently so that we can learn, or is it bad for you, your clients, et cetera, in having to deal with multiple jurisdictions doing things in different ways?
So I basically asserted that if things get too different, then that's the end of global standardization. So obviously, I'll say I don't think you can have global standards and systems that result in very different outcomes, right? Everyone understands that patents are national, and so I get, one thing we saw and heard in the last panel was George's view that every country should kind of stick to their own FRAND, but that's not how licensing is done. And I get the drive for that as an intellectual matter, as kind of like a clean jurisdiction of the way the law works matter, but that's not connected to the real world. In the real world, licenses are global, and so the question is how do you apply the law to the real world? If you force the real world to apply to the law, then you're going to break the real world. Is basically what's going to happen, and so. Some things might be interesting to be different among jurisdictions. I think natural experiments are fantastic, but global standardizations is already a thing, and if we break it, then it's going to be different. Maybe it'll be better, but it could be worse.
Again, I'll just come back to this point on, there's a big difference between pursuing damages, which is really practically your only option in the United States at district court, versus, Germany, where it's very much around the injunction. And then England's off on its own, tangent here. I mean, the English courts are reading in. If you ever look at the declaration that you make to Etsy, it says, to the extent essential, the patent owner is prepared to grant irrevocable licenses on FRAND terms and conditions. That's it. But the English courts have somehow read in, well, unless you wait till you can wait until the English courts decide what are FRAND terms, but you have to agree to those terms before we'll tell you what they are. Where does it say any of this in the contract? So there's good and there's bad. I think it's essential because the remedies are different in, say, Germany versus the United States. But when you see England getting off on these, judge-made rules that are just not at all supported by the contract or contract law, I don't think it's helpful. And I worry then by putting in these different proposed regulations from China and Europe, and now we're seeing the various agencies of the United States government asking for info on this, we're just going to make a complicated system that much more complicated.
Obviously it's inevitable that different jurisdictions are going to want to have different approaches, but I do share Fabian's concern that if China says the rate for this portfolio is X and the UK says no, it's Y or 5X, or how do you, and they do that on a global basis, I'm not sure where that leaves the parties, and how you navigate that if you have competing systems that are claiming to be able to determine these things on a global basis.
And me as an economist, I always think about, we want as a whole innovation to, move forward, and implementers to use the innovation to innovate on top of that, right? And if I think about a world that is highly unpredictable, I'm not going to invest in innovation. I'm not going to take the risk. And that is then, hampering innovation, hampering R&D investment, hampering implementation of standards, because I don't know if I'm ending up being sued everywhere and my products are blocked. So for both sides of the table, that would mean you basically would stop the innovation process. So at a higher, very high level, if it's unpredictable and the courts in different countries, you cannot know what the outcome will be, that's, I agree, then our innovation system is over.
I want to actually throw it back to Timothy Syrett. You mentioned these emerging areas of litigation. We've been talking all day about the UK and the EU and the United States and China, but now we have to worry about India and South America. And so do you see that as moving us more towards breaking the system or something else?
I don't know if it breaks the system. It certainly makes it more complicated. I think it does, it does favor a global solution. I mean, if you are a defendant and you can get a court to set global terms, we saw this play out in Apple Ericsson, where Apple went to the court in Texas and set a global rate, and then that was evidence that could be put before courts in other jurisdictions, saying there's a court in Texas who's working on this. But it does make it obviously more complicated. I don't know if it's going to break it, but certainly you can't say that Brazil isn't entitled to their own patent system. They obviously are. Every country is if they want it. So I don't see a way around it. But it does make life more complicated. And kind of to circle back to where you'd started, Kristen, in terms of thinking about it as a litigator, you kind of have to figure out what's the most stringent regime you're going to be potentially dealing with, and try to calibrate your conduct accordingly. Like, what is a German judge going to think of this letter or this offer, or et cetera? So that's, as a practical measure, I think, how it gets navigated.
Okay. Well, there's only one more question that I have on my list that I promised to ask them, but I'm sure there are folks in the audience that have thoughts. But the last question I promised I would ask them is that a lot of them remarked on injunctions, and which brings up the interesting space that FRAND is contractual, and as Kurt said, that a lot of this is a contract issue, but SEPs are patents, and the injunctions come from the patent side. And so I'm wondering what are your thoughts to the panel about how do you navigate this intersection of contract and patent when, again, you're in various jurisdictions and they're treating not just patent law differently, but also contract law differently, and how do you navigate that space?
Sure, I could take a shot at that. again, the injunction just seems to dominate the narrative here. But, and there is a real problem. It comes back to that there's this one chip you get from Qualcomm and all the inventions are in there. So if there's an injunction on that one invention, how do you pull that one out without taking apart the rest? And then further on top of that, you have like the Unwired Planet versus Huawei issue, where Unwired Planet gets an injunction on one patent in a country where Huawei only has 1% of its sales, and then they're trying to leverage that into a broader deal. So I don't know exactly what the solution there is, but I just would like, again, to see that, a more nuanced discussion around this point. It's not always the case that, you have this magic wand, you can make people do what you want them to do, but there has to be at some point, a limit to this, because otherwise, this stuff could drag on, and on forever. And I see it more like we have to keep the contract and the patent law separate. Okay, I sue you for infringement, and you don't have a license, then you don't have a defense. And now, if there's a breach of contract claim because I was supposed to give you a FRAND license and I didn't, then let's keep that separate, and let's look at breach of contract, and let's look at the damages associated with that. It's when we start mixing these two things together, and an unexercised right of a third-party beneficiary is not a defense to patent infringement. And I see it a bit more like a poker game, which is, if you want more information, you're going to have to pay more money. You're going to get more information at some point. But if you're wrong, you're wrong. And that's my understanding of how it works in Germany. They're not going to decide what the FRAND rates are, but they are going to take a look and say, well, did you get a FRAND offer? You turned it down. It's clearly not FRAND. The injunction goes ahead. Again, I don't know what the perfect solution there, balancing the injunction should be, but again, there is seemingly a limit there.
So, patent law is different in different jurisdictions because different jurisdictions have made their own calculation of the right balance of incentives for innovation and freedom, economic freedom. That's why there's differences, because that's been calibrated a little bit differently. And so kind of the question for me is what is different about SEPs than regular patents? Because if you have a portfolio of non-FRAND committed patents, of just ordinary patents, and you decide, well, I'm willing to license these, but only as a portfolio, and someone who's not willing to take a license on a portfolio basis, then you sue them on one patent and you win, and then you can get an injunction, and you're perfectly entitled to then say, I will enforce my injunction unless you take a portfolio license. That's full stop. That's the way patent law enables licensing of portfolios. And you can say that's good or bad, but that's just descriptive. That just is how the system of incentives works now. So the question is, what does FRAND do to that? How does FRAND interact with that or layer on that? And because FRAND is contractual. And to me, what it has to layer on that is FRAND is certainly not a defense to patent infringement because it's not a license, but I do think it is a defense to an injunctive remedy when there has not been a FRAND offer. I think the effect of a FRAND contract should be given is you must give a FRAND offer before enforcing an injunction. No, not as a matter of antitrust law. I think that should be interpreted as a matter of patent law. In general. As a matter of antitrust law, I don't think antitrust has almost no applicability in FRAND, and that's dying, and it is going to die, I think, except in the most extreme cases. So FRAND has to be there in some way, otherwise the system doesn't work. You can't really separate it out and say, okay, you got an injunction on your patent claim, and without giving a FRAND offer, and so the infringer's remedy for that is to go sue you for breach of the FRAND contract in a separate case. That's not efficient. I just don't think that that's practical. There are ways to square the circle, but But I don't think you can separate them out entirely.
And I guess I would further complicate it by saying that I think you do need, I think there is a role for competition law in two respects. First, I think, and Professor Contreras and others have written about this, that the FRAND commitment was adopted against the backdrop of competition concerns. And so I think it animates your contractual interpretation of what FRAND means. You have to give that some consideration as you think about FRAND. Now, obviously, the words on the page, to Curtis's point, mean a lot, but to the extent you're looking outside those words, I think you need to take into consideration the competition law concerns that shaped the contract. And then, as a matter, obviously it varies by jurisdiction, but in Europe, the Huawei versus ZTE test was established based on concerns about competition under Article 2, that you can abuse your dominant position if you're trying to enjoin a willing licensee. Similarly, the FTC here under Section 5 has taken action against parties that were enjoining willing licensees. So I think there can be a role. It's not going to be, not every FRAND case is an antitrust case, but I think FRAND cases can certainly involve antitrust given the right set of facts and circumstances.
Okay, well, I am going to open it for questions. Oh my goodness. Well, I'm glad I saved extra time for questions, and we have a helper here with a microphone in the audience, and go ahead and just hand it to somebody whose hands was up.
Keith Mallinson. Kristen, I think you said in the last session we were kind of asked a question about collusion and didn't really address it. So something along those lines. So
Are you taking this as an invitation?
I'm taking it as an invitation to make a comment.
Putting yourself under Kristen's jurisdiction, I would think long and hard before you did this. But okay, your funeral.
I'm going to hold you to time limits.
Indeed. So actually, there is coordination that goes on, and I think it's actually been quite healthy. I mean, when in standard essential patents, they're actually complements. So once you're in the standard, they're complementary. They're not in competition with each other. And we can actually see, we have a real-life experiment when we see in patent pools that you get something like ABC. You've got thousands of patents in there, and the rates are set actually in coordination, collaboration by the licensors. They're also, a lot of them are downstream, they make stuff as well, so they're mindful of their outpayments, and you actually have very modest royalties. So it kind of mitigates this royalty stacking kind of assertion. It's a live example of where coordination on the licensor side is actually very healthy. On the other side, though, if you allow, because it sort of seems to have disappeared or gone away a bit, the notion that the licensees should conspire together to set the rates. The notion of the licensing negotiation groups, the LNGs, I think but it bubbles up from time to time. That, I think, is a problem, and it is an antitrust issue, because if you allow that to happen rampantly, then you will get a buyer's cartel that will drive the prices right down to the ground. And I would welcome any comments from the panel on what I've just said.
I'll just quickly clarify my antitrust audible to Fabian here, but the point I want to make again is both the Federal Trade Commission and I assume you were referring to the Google Motorola consent decree, and then the Huawei ZTE decision from Europe, is there is no antitrust problems with seeking damages for past infringement. So I won't comment on the injunction side of it. Again, that's a hairier issue, much more complicated, but there is no issue. There's no mention of releases in the letter of assurance, so there's nothing in the contract about giving releases for the past. There's no antitrust concerns that I see, and there's nothing in patent law that says you have a defense to patent infringement if you have an unexercised right of a third-party beneficiary.
Okay, next question. We're going to keep our helper running around the room. This is great. Oh, wait a second. See, George should have just been up on this panel because we've invoked his name multiple. No, George, you're next. It's fine. But since everybody on the panel like invoked you already, we should have just asked you up here with us.
No, I was happy on my previous panel. That's okay. But I am gonna talk to Keith's point.
They're making their own panel over here.
I know. I see this.
Yeah.
I mean, you know, in pool negotiations, the buyers are there. They're being consulted, right? They've got to be some part of what goes into the price. Said it's not just the patent holders, and many of the patent holders are the buyers. Yeah. Okay. Enough crosstalk. So I have a real question. So and this is great because I always do learn something new from like these different panels. So lump sum payments. So I want to hear more about this. There are 3 scenarios I can think of where someone's paying a lump sum royalty for one of these licenses. I mean, one is just damages for past infringement, right? That's always represented as a lump sum. I don't think that's what you're talking about. You could just present value an expected future royalty stream, which is basically the same as, future royalties, but you've somehow estimated and calculated and present valued it. Or there's nuisance value, right? There's a nuisance value of lawsuit. There are definitely some patent suits that end up with a lump sum that way. But it didn't sound to me like you were talking about, and I'm talking to Curtis, obviously. It didn't sound to me like you were talking about any of those 3 options. And I'm just wondering, with a lump sum payment, like how would you defend against a claim of discrimination, against the ND prong of FRAND, if you're just negotiating a lump sum, that's not tethered to either, 1 or 2, like past infringement or expected future value, or is it that?
It was the second one. I mean, we do our best. We get market research data and we estimate, look at the term of the patent. But again, you have to understand, not all our patents have the same term. Not every family is covered in every region the same. And we do our best with the market data that's available. But that's not. But I'll put it back to you, Professor Contreras. How many phones is Samsung going to sell in 2027?
I don't know.
There's no way to know that, right? So that's why it's impossible. Pardon me?
That's why, I think Fabian's company and others, they just have a running royalty, right? With accounting.
But I don't work for Qualcomm.
No, I
We license hundreds of patents, not tens of thousands. And that's the difference, right? That we don't have. I'm going to steal this back from you. We don't have that bargaining power. So I'm really eagerly looking forward to the English court's decision in Optus versus Apple, because it seems like they said, well, Optus, you have the patent, so you have all the leverage, so therefore any deals you did are irrelevant. But Apple, they did all these other deals. Those are, well, who did Apple do those deals with? Because if they did a deal with, with a company like ours, we don't have bargaining power over Apple. And so it's just, again, when you look at a lot of these academic solutions, we'll call them, to doing it, it just doesn't seem to make sense in my world. If I'm Qualcomm or Ericsson with a big living portfolio, running royalty deals, 5-year terms, that's one thing, but that's not what we're doing.
So to me, first of all, there's way more lump sum deals than you think, right? In cellular in particular. Not that we do. Yeah, we don't do them. I hate them. But we've done partial ones. Right. So think about the situations where they're available, they make sense. Where they're available and they make sense is when there are different expectations, when the parties have very different expectations and ideas about what the future is going to hold. Because if somebody's very optimistic about their future and the other side is not that optimistic about their future or is pessimistic about their future, well, then they might be willing to pay a lump sum that they think, wow, I'm getting a great deal. And it ends up not being a great deal, or it might be. So I've been parts of negotiations with two situations where we've done partial lump sums, and so had to did this calculation, right? And I will tell you, one of the ones was a home run for us, absolute home run, and one of them, I think they exceeded their own best expectations. So it wasn't so great for us. That's the way it goes. I think courts are doing a very poor job of factoring that risk allocation into account, because it's very hard to do, right? And people are very self-serving, and so they just do math. But that's how the economics works from my point of view.
If you remember the InterDigital case with, I think it was Apple that was happening in China. No, sorry, InterDigital was somebody, Huawei. Thank you.
It was the Apple.
They had two licenses. They had one with Apple, and then they had one with Samsung. Well, when they did the Apple deal, Apple barely sold any phones. But then years later, the Chinese courts look back and say, oh, but they sold, a zillion phones, so therefore that wasn't the deal. Okay, that's like revisionist history, and now that we have all the answers, we know what it was worth, but that's not what it was worth to InterDigital at the time.
Did Tim or Timothy have anything to add to this one, or?
No, I agree with Fabian that the lump sums are very common, and I think in some ways they can be a way to not necessarily obscure what is discrimination, but you can say this is a different deal. They gave me the benefit of X million up front. That's a benefit to me as opposed to having to wait for it and to undergo the uncertainty. So, I think you can make arguments about how your lump sum fits within a framework, or kind of is, just depending on the circumstances of the deal.
And one comment, this is maybe a different kind of lump sum, but to me also the initial Avanci $15, no matter who joins, is a lump sum. That, if Fabian knew that so many others would join, maybe it wouldn't be $15. So, right, I mean, sometimes it enables markets to have a deal in the market to get started with, because it's just simple, right? And it's predictable. We know what's going to be there, and we pay now. Of course, the more cars you sell, the more $15 you pay, but at least that number remained the same no matter how much coverage the Avanci pool had. So I think also that was a lump sum deal that enabled somehow a market to agree to from a licensee point of perspective to a lump sum royalty, no matter how many SEPs are covered. Well, lump sum in a way that no matter how many SEPs are in, right? I mean, of course, the more cars you sell, the more $15 you pay, but the more SEPs are in the pool, you don't pay more, right? That was the promise, at least up until they had that final, which I think also is a fair, I mean, it's just a latecomer, first-comer, promotion. That's not even breaking a promise, I think, but at least, at the end, with Huawei joining, you pay $15 for 80-90% coverage, while when you joined, it was 30%, right? I mean, that to me is at least a lump sum of how many patents I get.
Hi. My name is Claudia Tapia from IP Counsel. I heard today, I'm not sure if I am misunderstood, but I heard that German courts don't always grant injunction. I can assure you this is not the case, and I recommend you to go to the website foripcounsel.com, and then you have the summaries, and you can find all those cases. Also, German courts have so far not determined FRAND. Doesn't mean that they will not do it. They haven't been asked to. I know some judges have been publicly saying that they will not like that, but it doesn't mean that they will not do it if they are asked for. But I have a question, which is more on a comment that I heard also about German cases on this shift burden of proof. And I'm not sure which court decision you have in mind, because for me, this is not accurate. So maybe you could clarify it. Thank you. That question is for Timothy G. Syrett.
Checking my notes here. I think I have it as the Sisvel v. Wyco. I'm not sure if I'm saying that correctly.
Right, but what is the SWIFT? Because in that decision, there was not change of maybe.
But I'm obviously not a German lawyer, but my understanding from reading about it is that what the court did was look at the counteroffer before looking at the patent owner's offer. And so under the Huawei ZTE framework, the third step would be to look at what did the patent holder make a FRAND offer, and if it was rejected, did the licensee come back with a FRAND counteroffer. And so instead of looking at step 3 first, you would look, the court would look at step 4 first and put the burden on the licensee to have made a FRAND counteroffer before considering whether a FRAND offer was made in the first place.
that's not my recollection. So I'm going to speak tomorrow about these case laws in Germany. So I recommend you to attend. Thank you. Yes, tomorrow, 1 p.m. Please come.
Hi, Kurt Levy, Committee for Justice. You've all been talking about getting injunctions, and my understanding has always been it's depending on where you are, it may not be so easy to get an injunction. But I wonder if you would discuss in which countries it's easier to get an injunction, either in the SEP context, or if you want a broader context, and then also. I'm just curious, how do company patent holders typically deal with, having an injunction in 2 countries, and do they just or I should say, how do I should reverse that? How do the I don't want to say infringers, but the implementers, if they're enjoined in 2 countries, do they just continue business as normal elsewhere?
I'll just make a quick little comment there. I said earlier, a patent's not a magic wand, standard essential patent, but neither is an injunction. I used to work for Acacia, and we got an injunction against ZTE in Japan, and you think, okay, well now they should do a deal, right? It's not that simple. They just changed the name of the product. You got to be able to find these products. Or your judgment was only on the one product they were selling before, and now they've got a different product. Or you've even seen in Europe some of the Chinese companies just leaving the market, and now you spent all that time, effort, and money to get an injunction, and you still don't have anything. At the end of the day, nobody wants the injunction. What they want is to get the other side to the table and try to strike a deal.
And an injunction is not a magic. It's not a magic wand. It's business disruption, right? It's imposing a cost on the infringer, and if they've been enjoined, I'm comfortable calling them an infringer. There has to have been a finding of infringement at that point, I guess, unless you're talking about a PI, but those are, in most jurisdictions, very rare. But it's not going to be magic. People get around them, as Curtis says, but they are a significant penalty, and should be available when people won't take a FRAND offer. But I'll just say again, I think you should show that you've made a FRAND offer.
I guess to answer the first part of your question, I think, subject to potentially clarification tomorrow, one, Germany is, at least in my experience, the biggest threat for granting an injunction. As I mentioned, Brazil, Colombia have kind of entered the picture. Courts in India have signaled a willingness to enjoin. And as I think I mentioned, Brazil and Colombia, they will grant preliminary injunctions. And those can even, in Colombia, in my experience, can even be on an ex parte basis. So that's kind of a quick strike, if you will, if you were able to get an ex parte injunction right off the bat.
One thing about Germany. The jurisdictions kind of decide whether their mechanisms for patent enforcement are more injunction-based, and they want the parties themselves to figure out the value after an injunction, or in the face of an injunction, or damages-based, like the U.S. and they calculate different. They put that calculus in different places. I actually don't think Germany is an outlier in willingness to give an injunction. I think most jurisdictions, an injunction follows infringement much as night follows day. What makes Germany very popular is that it's fast. The bifurcation, to some lesser degree, that's some been fixed, but not entirely. And that the judges are of high quality. But the speed, more than anything else, I think makes it attractive to patent holders.
It's also a big market too. So
agreed. It's also a big market. Yes, because the Netherlands has all of those things also, but it's not as big a market. So yeah, that's 100% true.
Okay, well, with that, we are out of time, and I am sorry that there were questions left on the floor. I would like first to have everyone thank our fabulous panel.